During tomorrow's hearing, both sides will have 30 minutes each to present their arguments. The state of Utah will defend voter-approved Amendment 3, defining marriage as between one man and one woman. The plaintiffs will make this argument.
When the Constitution said, "we the people," it didn't just mean we the people who the state thinks is worthy of recognition and equality. It means we all the people.
The appeal comes after federal judge Robert Shelby ruled last December that Amendment 3 is unconstitutional. At home in Salt Lake City, two of the plaintiffs, Cody Partridge and Lori Wood, say they put themselves in the public eye to put a face on the same-sex marriage issue.
They've created a scary straw man out there that it seems to be under attack, and we don't recognize that.
That's right.
The panel hearing the case includes three judges. Judge Paul Kelly Jr., nominated in 1992 by President George Bush. Judge Jerome Holmes' nomination came in 2006 from President George W. Bush. And Judge Carlos Lucero won confirmation in 1995, an appointee of President Bill Clinton. Legal scholars have various opinions on how the judges might rule, but both sides agree. The Windsor case, where the Supreme Court declared the Federal Defense of Marriage Act unconstitutional, will influence this ruling. But there's sharp disagreement about states' rights and whether the voter decision in 2004 on Amendment 3 should stand.
They were preserving a policy that they believe is demonstrated by experience to be what provides best the ideal setting for children to be raised.
Moody Sabaody and Derek Kitchen, two more plaintiffs, feel their case will, in the end, strengthen marriage.
Because we are pro-family, we are here to take care of one another, and overall I believe that this will be a benefit for society as soon as marriage equality is extended to all couples.
Well, good morning to you. One memorable moment in the courtroom came before the proceedings even started. Utah Attorney General Sean Reyes coming over to the plaintiffs to shake their hands and wish them well. He says it was an act of civility, but it caught all of those plaintiffs by surprise.
You know, I appreciate his outreach, and I don't fully understand his position. While I may not understand exactly how they feel, I wanted them to know that I've tried to put myself in their shoes.
Far different points of view reflected in rigorous questioning from three federal appeals court judges. Those questions probed past case law, particularly last summer's U.S. Supreme Court ruling on U.S. v. Windsor, which struck down the Defense of Marriage Act. This is the first same-sex marriage case to reach a federal appellate court since that decision. Utah argued the ruling did not clearly open the door for challenge on Amendment 3.
Windsor left completely open the question of whether or not states retained the right to define marriage in the manner they see fit.
The plaintiffs used the same ruling to argue the state's definition of marriage is unconstitutional, and they cited legal animus in Amendment 3, or harm created by what they called a flawed law.
The only purpose of it was to exclude same-sex couples and treat them unequally.
After the hearing, relief and joy as the attorneys and plaintiffs emerged, each side declaring victory.
But to us, the compelling argument is that the states need to have the right to be able to determine things as fundamental as marriage as they have throughout time through the democratic process. My gut feeling is that we are on the right side of history. I believe that our attorneys have put forth the strongest argument possible, and now we just need to wait for the decision to come down from the judges.
Again, it'll be at least 6 weeks, potentially months, before these three judges issue a ruling. In the meantime, the state of Oklahoma is arguing a very similar case in this very courthouse next week. Richard Piatt, KSL 5 News, Denver.